Mistakes that you can make in your long-term disability claim are relying on and using your disability carrier plan's Social Security claims representative. Now, most disability plans or policies require that you apply for Social Security disability benefits. Why? Because they get to reduce dollar for dollar any monies you get from Social Security for yourself or your family members. That obviously is something that they're interested in making sure they have the benefit of, even if you don't apply for Social Security disability benefits. And they'll generally offer you the services of a provider to assist you in filing that claim. I think that's a huge problem. Why? They don't have your best interests in heart. They're working for the disability insurance carrier, and they do it in a way that potentially can limit your benefits. Well, what do I mean? Many times the disability advocate will look at your medical records and understand that by the terms of the disability policy or plan, benefits are limited to just 2 years if you have a disability caused or contributed to as a result of a psychological condition. So what do? That advocate, if you will, in quotes, are going to be trying to develop in your Social Security disability claim conditions that would limit the disability carrier's payment of benefits to just 2 years. So you need to understand that they're going to potentially manipulate the situation so that the disability carrier pays you as little as possible. That holds true also for subjective medical conditions, mental nervous condition limitations, and so I think that you need to be strategic about this. I am an ERISA disability lawyer who also handles Social Security cases. And I want to handle both of those cases for my clients. Now, why do I want to do that? I want to make sure I understand the policy limitations. I also want to make sure that I'm developing the medical records in a fashion that helps me win both cases, but limits the carrier's ability to offset benefits. And one of the ways we try to develop a winning case is to use Social Security disability residual functional capacity forms. We Social Security lawyers have developed them for all sorts of medical conditions. I think there are about 60 of them. When you look at a Social Security disability residual functional capacity form and compare it to the attending physician statement form that the disability carrier has your doctor fill out, you can see there's a world of difference. The carrier's form doesn't ask the right questions on purpose. I want to make sure that the right questions are asked not only for your long-term disability case, but for your Social Security disability case, because we want to win both. Now, they may say to you, hey, if you use our lawyers or our services, you're not going to have to pay a fee. Well, let me tell you something. You get what you pay for. And if you're not paying for anything, you're basically getting nothing. But what's also important is, in my experience, when I represent a person in their long-term disability claim and their Social Security claim, and I get the Social Security benefits, the disability carrier will say, okay, yeah, we have the right to an offset, but we're still going to deduct the fee that you had to pay your lawyer. So that deduction occurs one way or the other. And it's in your best interest to be represented by an experienced attorney. If you don't believe me, go see my video that I did about Claimify. Now, in our next segment, I'm going to talk about why having an inexperienced lawyer represent you in your ERISA disability case is a huge mistake. Got it? See you soon.